Let's go on the record on cause number DC 202395, Ashley Cora versus Maji Mod El Khalil. Council, make your appearances.
Your Honor, Jules Slim for plaintiff, respondent to the TRO, Ashley Curiot.
And this is Stephanie Almayer on behalf of the counter plaintiff defendants, the high-tech defendants, Majdi El-Khalili, Faraz Mekbel, and Fadi Mekbel.
I'm sorry, I misspoke. I said TRO, I meant TI.
Okay. All right, let's go ahead and proceed. Call your first witness.
Your Honor, actually by agreement of the parties, we have presented evidence via affidavit for the court's consideration. That was filed on Friday with this court. So if I can just make some opening remarks, I don't know if there are any issues.
Make sure that's accurate with Mr. Slim. So you guys have agreed to submit this via affidavit?
No, absolutely not. I haven't agreed to that, but I'm not going to be disagreeable in that the 29th emergency order by the Supreme Court did say that the court may consider sworn affidavit testimony, but no, it's not by agreement.
I apologize. When I spoke with counsel on Wednesday, I thought we agreed to do this via affidavit. So that was my understanding. We have submitted the affidavits for this court's testimony. I'm not sure then if we want to discuss objections to our exhibits then before I proceed, because I have oral argument on the, as stated in the brief and the affidavits and exhibits that we filed on Friday.
Which exhibits are you offering?
All of them. Defendant has exhibit A through L.
Any objection to A through L?
Yes, Your Honor. They're all hearsay and relevance, Your Honor. I mean, we can go through each one of them one by one, but starting with exhibit A, for example, that's the Rule 11 settlement agreement at mediation. It's a mediated settlement agreement that's been superseded by the executed agreement thereafter, and therefore is not relevant. Exhibit B is...
Exhibit A is admitted.
I'm sorry?
Exhibit A is admitted.
Exhibit B is the settlement agreement to which you've been referring, and I noticed it is confidential. There is a confidentiality provision in the agreement, and it is stamped confidential. Therefore, I don't know why it was filed and made a matter of public record, but to enforce a confidentiality agreement, Your Honor, we would object to that being admitted as anything but
Exhibit B is admitted.
Exhibit C is a lease, and I'm sorry, these are all kinds of different sizes. Let me blow that up. Purports to be a lease, yes, between AQ Inc. and landlord James Johnson, who's the current owner's father. We have no objection to that.
Exhibit C is admitted.
Exhibit D is an eviction notice that I sent back in March 23rd, 2020. This gave rise to the first TRO. That eviction notice has not been reinstated, nor has it been acted on, and it's been entirely abandoned. Therefore, it is irrelevant. It's not going to support any irreparable harm or imminent harm, something that happened 9 months ago.
Exhibit D is admitted.
Exhibit E purports to be a business records affidavit of, who's that? Amber Barger. I'm not going to, well, under the Supreme Court order, it appears as though the court may consider sworn testimony, although I'm not sure that order is still good today. I'm just not sure. I won't object to that. I won't object to the business records affidavit.
Exhibit E is admitted.
Exhibit E1. Sorry, I can't get it centered on my screen. E1 is an email string between me and Brian Johnson and Scott Miller, as it does not purport to support any argument of irreparable harm or probable right on the merits, and that there is no lease between High Tech and Vox Property. We object to relevancy.
Response on that one?
Well, that email actually concerns the fact that, again, Mr. Kirab's obligations pursuant to the settlement agreement was that he had to use his best business practices to get the lease transferred. That is part of, that is a major concern and a reason for us bringing this temporary injunction hearing before the court. So it demonstrates kind of the lack thereof of Mr. Kirab trying to get this lease transferred to High Tech, my clients, which are his express obligations pursuant to the settlement agreement.
E1 is admitted.
All right. Just by way of reference, Your Honor, it states right there in the document, Amber Barger wants to be the point person on the new lease. And I was instructed not to communicate. But nonetheless, that's more for argument. Thank you, Your Honor. Exhibit F is the business records affidavit of Amber Barger. No objection.
Exhibit F is admitted.
F1 is a June 26, 2020 letter. No objection to F1.
F1 is admitted.
F2.
Did you say F2?
Yeah, we're at F2. This is an email string between Mr. Miller and Ms. Barger. This deals with the lease negotiations between High Tech and Vox Property. Again, it's not probative of irreparable harm or an imminent right that they're likely to win on the merits of anything, that there can be no cause of action stated that High Tech has a legal entitlement to enter into a lease with Vox Property. Is entirely at the discretion of the parties. There's nothing this court can do to order that lease to exist. So I object to relevancy, Your Honor.
Response.
In summary, exhibits F2, F3, F4, F5, and F6, which I know Mr. Slim will get to, kind of detail the lease negotiations that High Tech had with the landlord of the property. They're also to kind of demonstrate to the court that this repudiation argument that Mr. Kirab insists on making is actually not correct. We've always, we have been begging to pay the cancellation agreement under the terms of the settlement agreement. So it is simply to show that High Tech was performing its obligations under the settlement agreement. Mr. Kirab was not. You can see the lease agreement, and it is circumstantial evidence to demonstrate that we were having these conversations. And then when Mr. Kirab, we believe, got involved and began poisoning the well with the landlord, that the lease negotiations fell apart, and Mr. Kirab has refused to vacate the property. So I think they are incredibly probative of what we're here today and demonstrate why we need a temporary injunction.
Your Honor, there's no evidence before this court that Mr. Kirab has poisoned the well. This is simply them trying to get you to order a lease and lease rights without a statute of frauds, without negotiation, without arm's length, and completely out of the court's authority. As the court is aware, the court has no authority to order contracts to be written and enforced, and therefore cannot support the necessary element of probable right. So we object to F1 through 5. Actually, let's go to 6, F1 through 6 on that basis.
F1 through 6 are admitted.
G is their notice to vacate to us. That's no objection to that.
G is admitted.
H is a business records affidavit of Majdi Khalili. No objection to that.
H is admitted.
H1 is the request for mediation. I object to relevancy, Your Honor. That doesn't have anything to do with
Yeah, why is that relevant, Ms. Almeida?
We put that in there because we wanted to make sure that the court understood that our argument was that the Rule 11 settlement agreement made us mandated that we mediated before bringing this forth to the court, and Mr. Kirab refused to comply with that. We just want to show that all the conditions precedent to us bringing forth this action were actually complied with by High Tech. That is the purpose of that.
You're not trying to get into any issues about what happened in the mediation, just
No.
that you requested mediation.
That's correct, Your Honor.
H1 is admitted then.
Did you say admitted?
H1 is admitted for that limited purpose.
Same for H2 and H3. They're all basically one email string, Your Honor.
All about setting the mediation.
Yes, Your Honor.
H1 through H3 are all admitted for that limited purpose.
All right, thank you. And going to I, which is the verification of Majdi Al-Khalili. This document is replete with hearsay, Your Honor. So I will object to the entirety of this document as to hearsay. It's not just a business records affidavit. He goes into great detail about things that happened or didn't happen, and that unless she's going to testify today, deprives my client of the right to confront witnesses.
As a response, it is the affidavit, as Mr. Slim has already, noted, that both, I think, the Dallas County local rules as well as the Texas Supreme Court's most recent emergency order indicate that affidavits are available to use as evidence in injunctive proceedings as well as all proceedings, and that there is kind of the courts are to err on the side of admissibility for these business records affidavits. I mean, I think the hearsay objection, I'm not sure which part he's looking at specifically, but I would maintain that he's detailing the fact that High Tech has made those payments and completed all obligations pursuant to the settlement agreement, and that Mr. Kirab has not moved out and is still on the premises. So
the whole thing is hearsay, Your Honor. Again, and the local rules do not provide for affidavit testimony at temporary injunction hearings. It does provide at TROs, of course, and that's according to the Texas rules as well. But I'm not aware of anything in the local rules that say evidentiary hearings.
I think she's referring to the emergency order, not the local rules.
Yeah, well, she mentioned both. So yeah,
let me just clarify this. So there is the Supreme Court emergency orders, which I think you cited to, and I think you're right about. And then the Dallas County district judges also have an emergency order.
That is correct.
He's right. It's not in the local rules. There's nothing about this in the local rules. And so to the extent that you cited to the local rules, I think Mr. Slim is correct that
I apologize, Your Honor. I was referring to the Dallas County's emergency order, the Dallas County emergency order, which I do believe allows for testimony via affidavit.
I'm going to allow an I. We'll have to kind of see how this plays out. That if I'm convinced, I may allow Mr. Slim to take a deposition in this case, but of this witness, but I'll just have to be convinced of that. So, but I is admitted.
Exhibit J is a business records affidavit of Fatih Mekbel. No objection to the business records affidavit.
J is admitted.
J1 and J2 are just blank pieces of paper. What I think these are, and I'm sure Ms. Almeida will tell us, these are the video clip. Pardon me. These are the video clips of the shipping to the back of the building. Is that what these are?
Yes, Your Honor.
And is that okay? J3 is a business records affidavit of Kristen Hecker, who's counsel, one of the attorneys in the case, and she would not have knowledge of the authenticity of the surveillance videos. She states, Exhibit J4 is a true and accurate depiction of events that were captured on high-tech video surveillance. I'm sorry, she would have no knowledge of that. She's not qualified to testify to that, and it's not there. She's not a custodian of those records, therefore it can't be They can't be under a business records exception. And I would also say, to the extent there's any video speaks for itself, Your Honor. So I would object to J3 on relevance and hearsay and failure to comply with the requirements of the business records exception.
Sure. To clarify, Your Honor, Exhibit J, which has been admitted, contains J1 and J2, which are movie clips or, movie images. Ms. Hecker in my office used those movies and created time-stamped images, which are attached as J4 through J8, which is why she did the business records affidavit, as she was the person that created those time-stamped images.
Let me ask this. I want to make sure I'm kind of following this. So there was video taken of Mr. Korab allegedly moving things into the building, and that's what J1 and 2 are. Is that correct?
Yes.
And then, and who proved up J1 and 2? Is that
Faraz Mekbel? That's the affidavit of that was admitted in Exhibit J.
And can you spell that name for the court reporter?
FERASMEQBEL.
And he is someone with the company, I assume?
Yeah, and he's also a defendant in this case. Yes, he is the general manager of High Tech.
And just to be clear, and so the reason that your associate or partner, I don't know if she's an associate or partner,
He's an associate.
Colleague created the second affidavit was to prove up the basically still shots of the video, but she's not proving up the video itself.
No, she's proving up the images, the timestamp screenshot images that she took.
So J1 through, understanding that now, J1 through 8 are admitted.
The Exhibit K is the affidavit of Faraz Mekbel. This again creates, it includes rank hearsay more so than would be otherwise acceptable. And I appreciate the judge offering me the opportunity for a deposition because in this affidavit, he states, he tries to describe attempts of a physical altercation, et cetera, and throwing wastewater, if I'm reading it correctly, which would be after this court entered the TRO. And I have Mr. Kuryab here to testify personally. I think Mr. Mekbel should likewise testify personally to this blatant craziness. So no, I'm going to object to that as hearsay.
He's describing conversations and actions of Mr. Kuryab, which I believe would be an exception. It's a statement of a party opponent, and a first person experience, which I also believe are exceptions to the rule. And again, under what I believed was the agreement of the parties and the Dallas County's emergency orders, as well as the Texas Supreme Court's emergency orders, that affidavit is there to show kind of the imminent harm.
Let me ask a question here, because I do share some of Mr. Slim's concerns, which are what I normally do in this type of situation would be, because we don't want to have live testimony, we don't want to put people at risk, is to allow a remote deposition to take place. What is the status of the TRO? Is that TRO currently in place?
Yeah, it's the subject of an interlocutory appeal, which I filed the day it was entered. But of course, interlocutory appeals don't stay court proceedings, so on we go.
I guess what I was asking is, has it expired yet, or when does it expire?
No, I suppose today, date of the TI hearing.
Is this within 2 weeks of the original TRO?
If it is.
It was. I will say, with some of the dates of the order, I think there's an argument that it could be 14 days from now. I think you had dated the order a little later than the original TRO hearing.
What I'm trying to get at is if there's these, I guess, is it 2 different people that provided affidavits that he's objected to?
Yes, Your Honor.
I don't remember their names, but the 2 people he suggested, what one thought would be to allow all three of these folks to be deposed, the two people for your affidavit, and then Mr. Korab. I could extend the TRO that's currently in place. You could research the issue of the receivership. We could reconvene maybe in about 2 weeks, keep the TRO currently in place. I could extend that with my inherent power. And really, I could probably do it more than once with the emergency power, but just under the rules, I can extend it 2 weeks. And give you a chance to take these depositions.
If the court is inclined to extend the TRO, I can bring Mr. Mr. El Khalili and Mr. Mekbel live.
No, I don't want. The thing is, I don't want you to. I want you to do it.
No, I appreciate that. I understand, and that's why I thought we had this agreement was for the the timeliness of the court and expediency. I'm a little shocked that we didn't. Now it's my understanding that we don't have that agreement. But if that's what
is there something in writing where he agreed, or was it just
no? It was a phone conversation.
Mr. Slim, what do you? I guess you have two choices. Either you can withdraw your objections and we can just go forward with the affidavits, or I'm going to extend this for 2 weeks, give you an opportunity to take those two depositions. She could take the deposition of your client. You submit all of these by deposition, and at the next hearing, we could discuss the receivership and finish the TI.
Yeah, I'd take the depositions. Thank you.
Ms. Almeida, so you have two choices now. Either we extend the TRO or you withdraw those two affidavits. You want to talk to Ms. Varga about it?
Could I? Would that be possible?
Yeah. Who else? I'll put you, and then your client. I can't tell if your client's here because there's somebody here I don't know. Do you want me to put? Who do you want me to put into the?
Just Ms. Barber. I'm not sure who the other parties are.
Okay, I'm going to put you guys into a breakout room, and then Mr. Slim, who do you want to go into a breakout room with?
Well, there was one more objection, Your Honor. It's the last one. You want to go ahead and finish that up before?
Yeah, let's do that.
All right, that's going to be. What happened? Where is it? Okay, the certificate of occupancy, Your Honor, which is Exhibit L, does not appear to be certified. Well, let me see. Maybe it does. Let me make sure. You know what? It probably comes with under 902 on self-authentication because it has. Does it? It should be signed under seal. I see a signature, but I don't see a seal unless it's watermarked somewhere on the page. I'm looking very carefully to see that. Well, if it's not certified, they can get it certified. No objection to L.
L is admitted without objection. All right, so who goes into your room, Mr. Slim?
Kuriab, Mr. Kuriab.
Who is MB7 plus?
Yeah, I think that's correct.
Okay, there's an Ashley Kuriab and then there's an MB7 plus.
I thought I saw him in both. Ashley, can you unmute and tell me where you are?
MB7 plus.
Okay, I'm going to go ahead and put both the folks in. How much time do you need, Ms. Almeida?
If I could just have like 5 to 10 minutes.
I'll go ahead and put you in for 5 minutes and then just bring you back.
Thank you.
All right. You should get an invitation.
I got it.
Oh, I'm going to assign, never mind. Okay, go ahead. So did all of that